We have good news and we have bad news for most of you from the Supreme Court this week. Now, I think it's only fair to start with the good news, so why don't we do that? That's the case of the town of Greece v. Galilee. That came down in a 5-4 decision, and the short version is that, yes, prayer before a town council meeting is okay. Here's Bill Rylich, who's the Greece, in upstate New York, Greece town supervisor, just yesterday speaking about what he thinks was the right decision in this case.
We gather as the town board of the town of Greece. We gather as Americans. We gather as neighbors, and we start our meeting with a prayer. And today we receive the affirmation from the United States Supreme Court that this practice can and will continue.
Now, this was a very close decision, as close as it gets, 5-4, and all of the usual suspects on the left and the usual suspects on the right stayed on their sides. Kennedy was the swing vote, and it was thus decided. What's interesting that all 9 justices actually believe that it's okay to have prayer before some kind of a government meeting, and that's on the basis of tradition. Where they broke away was on just, well, how inclusive is that prayer and what's the content of that prayer? And that's where things got a bit trickier. But first, on this issue of the heritage of saying prayers before meetings, Justice Kennedy, writing for the majority, wrote that legislative prayer has become a part of our heritage and tradition, part of our expressive idiom, similar to the Pledge of Allegiance, inaugural prayer, or the recitation of God Save the United States, and this honorable court at the opening of this court's session. Essentially, he's saying this is so ingrained into our governance and has been from the founding that it would be, quite honestly, bizarre to now decide, no, you can't have anything religious, even vaguely religious, involved in any government ceremony. And this was, by the way, as in this town of Greece, it was just in the ceremonial part, not in the actual deliberation over legislation. So they held that this was okay. Now, where there was a break was in the issue of just how they would define coercion. Justices Scalia and Thomas were actually even further along the line. They said unless you're forced to take part in this prayer, then it's okay. The other justices thought that it was a little trickier than that, a little more specific than that. They had a test, a coercion test that they came up with. But the majority upheld legislative prayer, and they said that absent a pattern of prayers that over time denigrate, proselytize, or betray an impermissible government purpose, a challenge based solely on the content of a particular prayer will not likely establish a constitutional violation. Now, do you think this coercion test, by the way, which replaces the establishment test of O'Connor, is this going to only invite more challenges? Because there's a bunch of things here that actually...
It's not going to end any challenges. It's not going to keep the court out of this argument. It's going to, they'll continue to be a part of it. I think what was validated today, Buck, is that you in this country have the freedom of religion, but you don't have the freedom from religion. And as long as it's not coercive, as long as you don't have to participate, just because you might be uncomfortable or offended by somebody else's views, you don't have a right to be free from hearing them.
Religious freedom beat out the right to not suffer offense, essentially. Well, there's more to this, and there's also the bad news case, which I want to get to in just a second here, but let's bring in an expert to help us weigh in on these issues. Joining us now is Dave Kopel. He's a professor of advanced constitutional law at the University of Denver and research director of the Independence Institute. Dave, thank you for joining us.
Oh, thank you for having me.
So in the dissent, it was pretty clear that the problem was that this was the court, the dissenters, Kagan writing for them, that it wasn't inclusive enough and that there wasn't enough of an attempt made to bring in other voices here. Do you think that this is going to stand for a while? We know we have a case coming up soon where they're going to look at whether a public school can hold its graduation ceremony in a church with religious symbolism everywhere. Is this a big step forward, or is this just maintaining essentially the religious freedoms that we already have?
Well, I think it's really underscoring the point that history and tradition are very important in analyzing whether some government practice violates the First Amendment's Establishment Clause. And that point is a lot clearer after the Greece decision than it was before. And I think that adds a major new element to First Amendment jurisprudence.
David, this is Tara Setmayer. I have a question about some other cases that are the religious freedom aspect of it. Recently, there have been incidents where kids have been told they can't read their Bibles in school during free time. When elementary school kids, they have free time, their teacher says you can read a book of your choice. There was a kid recently who had a teacher take it away from him. He read the Bible, and now there's a pending lawsuit going forward about that this was a violation of their First First Amendment right of freedom of religion. So do you think that something like this, rulings like this, will help to bolster the case for people that, yes, you do, just because we want to exercise our religion by ourselves, that's not offensive to anybody else, so leave us alone? Do you think that things like a case like this or a ruling like this helps to support and allow that religious freedom to continue?
Sure, and I'd say Justice Kagan's dissent helps on that as well, because all 9 of the justices were unanimous that the First Amendment does not require that everything around a government be some kind of religion-free zone. All 9 of the justices agreed with the concept that legislative prayers are okay. So in the case of the student, I think there's a strong case, because when you worry about religion in the schools, like say if the teacher is reading the Bible during study hall, well, at least arguably that a student might take that as the school or the school district or the system endorsing the Bible. But if it's just students themselves reading whatever they want, it's pretty hard to argue, to me it seems, that anybody is coerced or would be mistakenly think that the student's choice to read what he or she wants somehow reflects the view of the school.
Well, David, now we got to turn to the bad news portion of it, at least bad news from the perspective of this table, and that's a case that will not, in fact, be heard. Petition was denied by the Supreme Court, and it's in the case of Drake versus Juragian, and it's about handgun laws in New Jersey. Now, we know from the 2008 Heller case that you can keep arms in the home. The Supreme Court has weighed in on that, but it's now not yet settled as to whether you can bear arms. The court hasn't weighed in specifically on that issue yet, and there's, in fact, some conflicting decisions at the appeals court level. But in New Jersey, for example, this is what you need to get a handgun in New Jersey. You would need to prove a justifiable need, an immediate threat to your life. You have to get local police approval. Then a judge also has to approve. That's where the double review process comes in. The local prosecutor can veto it, and then you have to go through this whole process every 2 years to keep a handgun in the state of New Jersey. And then we know from Reason.com, they ask a very basic question about the Supreme Court's refusal to tackle this. When is a right not a right? Americans are not required to justify their need to exercise a fundamental right. If the government can force you to provide a reason to exercise your right, then it's no longer a right. Dave, it seems like that's pretty clear here, that if you can't carry outside the home, how do you have a right to bear arms?
Oh, I think that's a fair point. And New Jersey is an example of a few states that have a right to a licensed carry system in theory, but in practice, hardly anybody ever gets a permit. I don't think the justifiable reason is the problem in itself, because I think you could say, well, lawful self-defense pursuant to my Second Amendment rights is a justifiable reason if that were properly and constitutionally interpreted. The real issue is this assertion that you have to be under an imminent threat, because by the time you're under an imminent threat, it may be too late. And the Second Amendment doesn't limit the rights only to people who are under imminent threats. You can have a gun for protection regardless of whether the threats against you are imminent or not.
Right. The whole purpose is you can't necessarily see the threat that's coming your way.
I think just at a very rudimentary level, the fact that they just chose not to take this case up is big enough of an issue for me, regardless of kind of the nitty details of what types of laws they have, because this is something that is so hotly contested. Hillary Clinton spoke at a conference today talking about limiting gun rights. This is such a big issue today and something that people care so much about that I think we've reached a point where this is something that they should have taken up.
Well, this case has been notoriously hands-off kind of on what they want to decide about, and that is reflected in the religious freedom case as well as in this case, and they don't want to rule too hard on this or don't want to say too much about that so and to me this looks very much in their character so far and the decisions they've made so far, but not necessarily a good thing for the Second Amendment.
I wonder where that Ninth Circuit case comes down on this, where that fits in. Remember, we talked about that not too long ago, where the Ninth Circuit, of all places, ruled on the California law.
You got to have concealed carry
you got to have one or the other. You can't have, you can't get rid of both. So now that they've decided not to take this one, I'm not sure on what the grounds were, what the legal grounds for their denial to take this on. But I wonder if, this is not going to be the last of the Second Amendment cases that we see.
David, Tara raised a very good point. There's conflicting opinions right now at the appeals court level as to whether you need to be able to actually bear. You can keep them in your home, but can you bear them? Why didn't the court take this case, and when will they settle this issue? At some point, they're going to have to.
Well, but they don't. They have almost complete control over their docket, and there's lots of issues where different courts, like as you're saying on carry, the 7th Circuit, which covers Illinois, and the 9th Circuit, which covers California, have issued very good decisions upholding the right to bear arms. And the 2nd, 3rd, and 4th circuits in the Northeast have gone the other way. The Supreme Court often lets circuit splits go on a long time. And I think one of the things that I suspect the court may be doing is saying we are reluctant to impose strong change on a large segment of the population. We want to wait till there's more of a national consensus. Now, in this country, over 40 states, you do have, as a practical matter, the right to carry arms because they have fair and fairly administered licensing systems. But there's still a large population of, New York, Maryland, and Massachusetts, for example, where the right is often denied.
I mean, but we are talking about an enumerated constitutional right, and yet we can't seem to get a fair hearing on this. David, we got to leave it there, unfortunately, but thank you for joining us and sharing your expertise.
Thank you.
Misfit Stories next. Stay with us.